So welcome everyone. So yesterday we have discussed the secondary evidences in relation to a document, and so we have completed the both types of evidences in relation to a document, that are the primary evidences and secondary evidences. And along with that, we have also studied the best evidence rule under section 59 of the Adhiniyam, which says that when evidence is to be given of any document, so evidence must be primary evidence. If primary evidences are not available, then only secondary evidence can be given, provided that it fulfills the conditions mentioned under section 60. So those conditions under which secondary evidence come into play in place of a primary evidence, so conditions are prescribed under section 60, which provides exhaustive list. So we will be covering all those conditions under which the evidence of a secondary nature can be given in place of a primary evidence. So first situation under section 60, when the original is shown or appears to be in possession or power of a person against whom the document is sought to be proved. So ये डॉक्यूमेंट जो दस्तावेज हमें न्यायालय के सामने प्रस्तुत करना है, और वह दस्तावेज ओरिजिनल प्राइमरी दस्तावेज यानी कि प्रमुख दस्तावेज किसके कब्जे में है? उस पक्षकार के ही कब्जे में है जिसके खिलाफ हमें सबूत पेश करना है, या फिर जो असली दस्तावेज, जो प्रमुख दस्तावेज है, वो ऐसे किसी व्यक्ति के पास है जो बहुत ही दूर है और न्यायालय के प्रक्रिया से वो बाहर है. सो एनी पर्सन हु इज आउट ऑफ रीच ऑफ अ कोर्ट और एनी पर्सन लीगली बाउंड टू प्रोड्यूस इट. और यहाँ पे तीन बातों का ध्यान रखना है अंडर फर्स्ट कैटेगरी. फर्स्ट इज दैट when the document which is to be proved is in the possession of a person against whom it is to be proved, and second thing, when it is in possession of a person who is out of reach of court, and third thing, when any person who is legally bound to produce the document, but after giving him a notice to produce the document and he declines, he does not produce the document. सो इन दैट सिचुएशन, अगर पक्षकार को हमने सूचना पत्र दिया कि आप प्रमुख दस्तावेज पेश कीजिए न्यायालय के सामने, लेकिन वो नहीं करता, तो हमारे पास क्या रेमेडी है? सो देन द सेकेंडरी एविडेंस ऑफ दैट डॉक्यूमेंट comes into play because of the requirement, because primary evidence is not produced by that party, even notice is given to him. So this is the first situation under which we have discussed three types. The first one, when the person against whom document is to be proved is in his possession, and second one, when the document is in possession of a person who is not under control of the court. Third one, when any person who is legally bound to produce the document but he is not producing, even notice is given to him under section 64 of this Adhiniyam. So we have completed the first situation under which secondary evidence comes into play. So let's move to the second situation, when the existence, condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved. So for example, when document is to be proved against a person or a party, and that person or a party has admitted in writing regarding the contents of that document, then the evidence of secondary nature can also be given. जब जिस पक्षकार के खिलाफ हमें कोई दस्तावेज को साबित करना है और वही दस्तावेज को वही पक्षकार ने लिखित रूप में उस दस्तावेज को स्वीकार कर लिया है तो उस दस्तावेज का हम गौण साक्ष्य प्रस्तुत कर सकते हैं। ठीक है जी। द रीजन इज दैट द पार्टी अगेंस्ट whom we have to prove the document has already admitted in writing regarding the contents of that document. So this is the second situation when secondary evidence comes into play. So let's move to the third situation, when the original has been destroyed or lost, or when the party offering evidence of its contents cannot for any other reason not arising from his own default or neglect produced it in a reasonable time. जब प्राइमरी डॉक्यूमेंट खो चुका है या खराब हो चुका है, सो दैट्स ऑब्वियस, जब असली ओरिजिनल डॉक्यूमेंट हैज बीन लॉस्ट और डिस्ट्रॉयड, तो ये तो अनिवार्य ही है कि उसका गौण साक्ष्य दिया जा सकता है। सो फोर्थ वन, when the original document is not easily movable, which means it is very difficult to produce the original document before the court. So as we have already discussed, the document can be any substance. It can be a text on any stone or on any wall, so or on any substance. So any substance can be a document. So when the substance is very large or very heavy, so it is very difficult to move that substance or that document. So again, it is a necessary requirement of secondary evidence. So in that situation, when the original is very large or very heavy substance in form of a document, so it is very difficult to bring that piece of substance or document before the court. In that situation, the photograph of that document or any other secondary evidence can be given. So this is the fourth situation. Let's move to the fifth one. When the original is a public document within the meaning of section 74. So we will be discussing under section 74 what are the public documents. So all the public documents are in the custody of the authority. When we want to recheck or want to get the public documents, the prescribed officer provides us certified copy under his signature and seal. So that certified copy can be given in evidence as form of a secondary evidence. So fifth one is the when any document is the public document. So of that public document, we can produce certified copy before the court as form of a secondary evidence. So this is the fifth one. Let's move to the sixth situation. When the original is a document of which a certified copy is permitted by this adhiniyam or by any other law in force in India to be given by evidence. So that is in relation to a certified copy. And let's move to the last situation, seventh situation, when the originals consist of numerous accounts, other documents which cannot be conveniently examined by in court, and fact to be proved is the general result of the whole collection. So the last one, when document which is sought to be proved is very numerous or very voluminous, is very large, so it is very difficult to produce whole of the document before the court. In that situation, when fact to be proved is the general result, general analysis of that large voluminous document, so then in that situation the secondary evidence of that document can be given. So these are the 7 situations under which the secondary evidence of a particular document can be given. So these are the exceptions to the section 59, which provides for the best evidence rule. So these are all are the exceptions, and this list is exhaustive list. When you have to provide the secondary evidence before the court, you first need to prove this thing, that primary evidence is admissible in court, and second thing you have to prove is that what is the reason and what is the circumstance that lead to the production of that secondary evidence. So you have to bring your case in any of these 7 situations in order to provide secondary evidence before the court. So these all are the situations under which secondary evidence can be produced in a court instead of a primary evidence. And section 61 to 64 deals with the production of electronic documents or electronic records. Section 62 is very important, which states that the contents of electronic records may be proved in accordance with the provisions of 63. So 62 gives legal validity to the electronic documents and electronic records, and section 63, it provides the procedure how the electronic document is to be proved before the court. So section 64 provides basic and foremost thing. When any party wants to produce electronic document or electronic record before the court, then the certificate has to be produced by the chief examiner of the digital records, so that it can ensure the credibility of that electronic document. The certificate will ensure that there is no tampering or any kind of changes in that electronic document. So section 63 provides for the procedure regarding the production of electronic documents before the court in form of an evidence. So from tomorrow we will be left with the, as we have discussed under section 60, under first situation, when any person is legally bound to produce the document, then he does not produce after giving the notice. But we will be discussing some situations where the giving of notice to person is not necessary under section 64. हम धारा 64 में पढ़ेंगे जब किसी पार्टी को सूचना पत्र देना अनिवार्य नहीं है, उसको बाय सिचुएशन ही उसके ऊपर ड्यूटी बनती है कि दस्तावेज को वो न्यायालय के सामने पेश करे. सो हम कल वो परिस्थितियां पढ़ेंगे जहां पे सूचना पत्र देना अनिवार्य नहीं है. So that's all for today. So you can have a quick look at all the situations and you can learn all the situations when secondary evidence can be given in place of a primary evidence.